think I'm going to go ahead and get started. Thank you everyone for joining us for Plants to Plants, the hemp processing seminar series from Sci-Fi Systems. My name is Emmett McGregor. I am CEO of Sci-Fi Systems, and we've been providing processing equipment, integration, and design, engineering, development, as well as consulting services, including technical consulting and project management now for over 6 years. I am very excited to have Graham Pechenik with us, who is going to be speaking to us about cannabis IP, patent filings, trade secrets, and everything else that you might want to know about in the arena of intellectual property. Graham, why don't you introduce yourself?
Sure, and thanks, Emmett, and hi, everyone. I'm really excited to be here too, so thanks for inviting me to participate in this. I really loved your series so far, so it's a delight to be able to be on it. So my name is Graham Pechenik. I am a registered patent attorney, and I do most of my work in the cannabis space as well as in the psychedelic space. The firm that I started, Calyx Law, I started in 2016, basically as a cannabis patent law firm to work specifically with cannabis clients. Before then, I worked for about a decade, primarily at the start of it, doing work for pharmaceutical companies. And then towards the end of it, for more technology companies, I was at a firm where I worked on some of the smartphone litigations representing Google and the Android sort of handset ecosystem. And then decided to sort of follow my passion and get out of working at 1,000-lawyer law firms and start my own firm. So that's what I've been doing since 2016, and really happy to answer some questions about it today.
Great. Well, yeah, always good to see the road to get into the cannabis industry. I know that expertise in the tech space in particular probably has been quite relevant, even though we see a lot more hardware and process type patents. I know that the details you get in there on tech you've probably seen a lot of strategies used that people are going to be trying to utilize in this space from tech. So why don't we start with the basics? What is a patent, and what are the types of patents that are relevant to cannabis? And then maybe we'll dive a little bit deeper into patent structure and how to understand what a patent actually covers.
Sure, yeah. So the very basics, a patent basically is a right that the government gives to an inventor for any new and useful invention for a limited period of time. And the basic policy behind that patent is the government wants to incentivize the innovation that takes place that can create more novel inventions. So it's basically like considered a bargain between the public and the inventor. So in exchange for coming up with something new and describing it in the patent application, the patent applicant gets this temporary right. So in the US, it's 20 years from the date of filing. And the right is a right to exclude, basically like a right to keep others from trespassing on what it is that's defined by the claims of your patent. So the patent's granted after generally 4 or 5 years, maybe of back and forth of prosecution, sort of like a negotiation with the patent examiner to convince the patent examiner that the invention you've described truly is new and isn't obvious. So the other sort of basic requirement of a patent is, besides just being new, which means it has to be different than anything else that existed in the prior art, it also has to be not obvious over it. So something that to a kind of ordinary person working in the field required some sort of inventive contribution. But by being able to convince that to a patent examiner, then you get the patent, which contains a set of claims, which then gives you the right for whatever is left of that 20 years after you've been granted the patent to keep anybody else from doing what it is those claims define.
Right, and that I think is a key part for those who might want to go and look at the patent record and try and understand where something that they want to do either is in violation of a patent, or may have been covered by a patent which has expired and therefore is no longer protected. That what is actually protected by the patent, sometimes it's phrased fairly confusingly, but the claims section is really all that's protected, even if there are pages and pages of background ahead of that that describe very detailed processes, procedures, or designs, right? So what's the, when you're reading it, how do you understand and differentiate between what's just being explained versus what the specific protections that are actually contained by the patent?
Yeah, that's a really good point. And I mean, as a patent lawyer, the first thing I do if I see any new patent is turn to the last page or the last couple of pages where those claims are. And patent examiners too will do the same thing when they see a new patent application come on their desk, because some patents, if somebody's seen them, they may in fact be dozens or even hundreds of pages. So, people are, examiner, for instance, who's pressed for time, is not going to read everything to decide what your invention is. They're just going to look at those claims. But as part of this bargain that I mentioned between the patent applicant and the public, the patent applicant has to be able to teach people how to make and use what they're asking for, what it is that's claimed. So the rest of that application, the written description, is supposed to just teach people, if they look at the claims, how they can do what it is that's defined by them. Because that's the bargain of the patent, is anything that's been claimed has to now have been disclosed in a way that people can duplicate it. So as soon as that patent expires, everybody else will be able to practice everything that it covers. So whether or not in reality that's the case, whether those requirements of describing and enabling somebody to do it are met, those are other things that are determined during that prosecution before the examiner. So the examiner will look at the claims of the application, see if there's prior art, make sure that anything that's in those claims is described well enough for somebody to be able to basically replicate it. And those are the things that the patent examiner really considers. And one of the things I think that's kind of important to recognize too, if people are looking at patent applications, is that lots of patents are published that may not be actual granted patents. So oftentimes, if somebody's looking at a patent application, they'll see claims that are incredibly broad, and very likely those, especially if they are really broad claims, those aren't going to be the ones that end up being in the granted patent. So as part of that negotiation, the patent applicant, or the patent applicant's lawyers will take basically the sort of strongest negotiation position they think they can take with the examiner, and then that'll get whittled down as the examiner raises prior art or says certain things aren't enabled enough for somebody to do, it's reaching too far into kind of the future beyond what's just been invented. And that gets narrowed down as part of the back and forth of the examiner. So, it's important to compare the differences between what may be in just a published application that hasn't yet been granted and a final granted application. One other thing maybe to just kind of throw in here too is patent applications don't publish for 1.5 years. So if somebody is going out and looking on Google Patents or another database to see if there's something that covers work that they're doing or something they're interested in doing, especially in a fast-moving field, it might not be out there in a published application yet, even though somebody may have already filed on it, just because there's that 1.5 year period of secrecy between publishing and, between filing and between publishing. And actually in the US, publication is not even required. So there may even be applications, as long as they're only filed in the US and not abroad, that don't publish up until they actually grant. So there is a lot of secrecy that's potentially out there.
Right, and that secrecy in the United States in particular could, the time between filing and the patent being granted could actually be potentially extended intentionally. Is that right? So that a process of modification and then engagement with the examiner, they could actually have a filing date that is quite early, and then keep pushing out the getting the patent issued in order to protect themselves from the publication of the process. But when does that end?
Well, it ends when the period of 20 years ends. So, if you've filed your application, so that 20-year period starts with the first non-provisional to be filed. So some people may have heard of like provisional patents. That basically gives you like an extra 12 months. So if you file a provisional, you have 12 months to file a non-provisional. That 20-year period, the patent term, starts with the non-provisional. So if you file the non-provisional, so you're correct that you can continue filing continuation applications even after you get a patent granted. That's not the end of your application. You may continue to get more and more applications kind of through the system granted up until 20 years, and you wouldn't have any term left. So, there's no point continuing to prosecute that application. But yeah, and not to jump ahead, but one of the things we may discuss later is the Canopy patent that's in the Canopy GW case, the one of the only patents that's been in litigation, and that one was filed in the fall of 2000, and it was just this past December that the patent that's in the litigation issued. So that was over 20 years actually. So I guess I should caveat what I said about 20 years. There are actually ways to get what's called patent term adjustment. So if your examiner is slow, which they often are, it's unfair, for the government to take away from your patent life by having a slow examiner. So if the examiner takes longer than a few months to do certain things, you get that time tacked back on to your term. So 20 years basically, if everything goes smoothly, but you may get a couple of years, or the particularly slow examiner, even 4 or 5, 6 years later. So that's maybe another thing to be careful about too, when thinking about whether a patent's expired or not, just kind of as a technical point that people sometimes get tripped up as. You may calculate a 20-year date, but you have to take into consideration patent term adjustment, and sometimes it's on the front of the patent, sometimes you have to go to the prosecution file, but it's good to be clear if you're worried you may be practicing something that's covered by a patent to ensure that the term really has expired. And Google Patents tries to tell you the expiration date, but it's not always based on accurate information. So it's important to double check.
Okay. Well, yeah. Do you want to dive a little bit deeper into that Canopy versus GW case? Since we brought it up, we might as well. It is, as you mentioned, one of the relatively few patent litigations in the cannabis space that is cannabis specific that has actually, is ongoing or has been brought to court. So, yeah, what's the background of that? What are the claims that they're disputing, and what do you think they're hoping to actually get out of the process of trying to enforce their patent?
Sure, and I guess maybe before I answer that, I'll say it's not just relatively few. There's currently one pending patent litigation, which is this case. There was another case that was filed a couple of years ago, people may have heard of, UCAN v. Pure Hemp, which was a case that ended after the plaintiff entered bankruptcy, and then the case was stayed, and then it went away. Those really have been the only two patent litigations filed. There was one sort of post-grant review, which was a challenge to a GW patent, but it was an administrative hearing. So there's really only been two federal court cases. So one of the things that's, maybe just as background here is patents, as I mentioned, take a long time to be granted, 4 or 5 years, sometimes longer in prosecution, but oftentimes their value of them may take even longer before they find, the market having people that are potentially infringing it. So, the patent time scale, as somebody who's worked as a patent lawyer for 15, 16 years, like it's amazing how it's kind of slow when you look back, things sort of progress. And that's one of the things maybe it's kind of interesting to have in your mind when you think of a very fast moving space like cannabis, where technology really turns over pretty quickly, how that kind of maps on. But anyway, so going to the GW Canopy case specifically, so Canopy sued GW for GW's Epidiolex product. So, their FDA approved CBD for, I think, 2 types of epilepsy. Canopy Growth's patent is a patent that covers subcritical CO2 extraction processes. So GW allegedly is using Canopy's patented subcritical CO2 extraction process abroad, and then the product of that process they're importing into the US. And that product is Epidiolex. Epidiolex is a very high revenue product that's, I think, making over $40 million a month for them. Something over $1,250 is like their, I think their like list price per 100 milliliters of their, the CBD. So obviously it's more than one would typically pay at a dispensary. So there's a pretty high kind of cost basis here for what the, the outcome Canopy, I imagine, would be hoping for. So in a patent litigation, if you win, you basically can be granted either the lost profits that you would have made but for that infringement, or what's called a reasonable royalty. So if Canopy and GW had sat down at the bargaining table once Canopy's patent was issued and negotiated over what the royalty rate would be, like that sort of kind of pretend arm's length negotiation would be the royalty rate that the court will enforce GW to pay to Canopy. So kind of depends on circumstances, but oftentimes it's maybe in the low single digits. Just as kind of a rule of thumb, that, on $40 million a month, that can be certainly enough to take the kind of the lottery ticket of that patent suit, and hope that you maybe will have a chance of convincing a jury. So one of the things that's kind of notable for, I think, patent lawyers who pay attention to the case, it's filed somewhere called the Western District of Texas, where they have patent cases that move very quickly and are incredibly plaintiff friendly. So the jurors there are very easily swayed by the narrative of the inventor, who came up with some some new innovation through their hard work and sweat and labor. And here's this other company, especially maybe a foreign company, who's stolen their innovation and is making all this money off of it. So presumably at the end of the day, that's what Canopy is hoping for, is to convince 9 or 12 or however many people in Western District of Texas that this invention is something that they should be entitled to getting damages from GW for.
Right, and so in this case, like you said, the damages are lost royalties and not necessarily, they don't consider the sale of that product as being like 100% taking out of the potential profit that Canopy could have made on the product if they were to manufacture it, right? It's really, they just look at it as they would have licensed the IP. Is that true in most cases? So if there was a thinking about, maybe we can use the United Cannabis as an example. So theirs, I think, was a way to functionalize their product in order to make a certain type of product profile, shall you say, a type of form factor to consume the product, and with specific benefits to that form factor. So would it, in their case, it was also, they could never go and just claim, we think every product that they sold outcompeted our product that we are selling, and therefore every dollar that they made is damages against our potential sales. Is that?
Well, so those are the two options for damages. One of them is lost profits, and the other one is that reasonable royalty. So there's different requirements that you need to prove to be able to be entitled to lost profits. So you would have to show that you had the ability to make those sales. So for Canopy, for instance, because this is an FDA approved product, like, is Canopy placed to be able to make those specific sales, and whatever the other requirements would be to be able to show that they were entitled to lost profits. So oftentimes it comes down to reasonable royalty, unless these are two companies really who are competing in the same market. So if it was a dispensary shelf CBD and Canopy was making some, and GW was also making some, and Canopy could have some expert that they brought on to testify to say, if GW wasn't in the dispensary at all, Canopy would have taken and made all of those sales. Maybe they could get the entirety of the the revenues that, or the profits that that GW made. But these circumstances being a little bit different, certainly if GW would argue that Canopy wouldn't have had the ability to make $1,250 selling their CBD, because it was only them who had gone through the FDA approval process that were able to charge such a hard price.
Okay, and yeah, there's a question from Brendan Hussey, and he's saying, can a plaintiff like Canopy determine if the how often can a plaintiff like Canopy determine if the defendant like GW is using a hidden manufacturing process or processing technology? And so to take this even more broad, trade secrets versus patent protections, and can we distinguish from non-disclosed processes versus trade secrets, and how those interact and how they're different than patent And then, for example, how if Canopy, how did Canopy even discover that that this was something that they might have a claim against GW for? So I know that's
Yeah,
several
no, and
questions
those
in
are
one.
all good questions, and I'm sure I'll miss some of them in answering, because I'll forget a few of
I'll
them as
follow
I
up. Yeah.
as I give you an answer. So yeah, please do follow up. I mean, so one of the things when you file a patent litigation, a patent infringement suit, you actually have to show some basis for why you think the company is infringing. You can see from Canopy's complaint that they had information just from GW's website that showed that GW allegedly was using this particular process, or enough at least to sort of clear the initial hurdle of bringing it to court. And then once now it's kind of in court, the ultimately, of course, Canopy as a plaintiff is going to have the burden to show by clear and convincing evidence that GW is in fact using their process. In the U.S. at least, the court and the judge can be sort of convinced to give discovery basically to Canopy. So Canopy can say, okay, so we know GW is, or at least we think GW is performing this process. We don't have all the details we need to prove it, but they can issue requests to GW both to like give them documents, to give them witnesses, to provide the information that Canopy sort of needs to make its case. So it's not possible for GW to say, I'm not going to give you anything. I'm not going to provide any details to you. So typically the way this kind of plays out in litigations, and I spent the early part of my career doing mostly patent litigation. So I have had the annoyance of spending many days at the beginning of lawsuits fighting about this discovery. I mean, it's letters back and forth where you ask for certain things. So you can imagine Canopy says, okay, give us all the details about your process. And GW says, well, here are some details, but they don't give them everything. And they fight back and forth. Maybe they'll go to the judge and they'll ask the judge, like, okay, we're not getting all the information we need. And the US actually has kind of what's called like a burden shifting procedure, where if you can show some information, you may actually kind of force GW now to sort of like prove that they're not doing something. But yeah, I mean, it is from the very outset, even to make that initial hurdle of being able to file a complaint to bring something to court, you have to have some information. And with a process, if it wasn't on their website, or if it's another company doing something that maybe is a little bit more narrow than like GW's allegedly infringing process, which is because Canopy's claim is so broad, it's subcritical CO2 extraction. That's a little bit easier to be able to argue that somebody's doing that than say if it was a particular extraction method that really required specific parameters or specific equipment or something, extra processing steps that it wasn't really able to be determined from the outside. Those kinds of things, when thinking about what patents are valuable, those are things that make policing patent rights very difficult, because it is very hard to find out what somebody's doing.
Yes. So can you talk a little bit about the difference between trade secrets and patents, and how trade secrets apply to this industry more broadly?
Yeah, so I mean, so I guess kind of a place to orient us to that conversation is just by looking at the fact that like a patent is only as good as you're able to enforce it to take advantage of that right to exclude. So to be able to do that, you have to know what somebody else is in fact doing. Where that's difficult, the patent maybe is actually working against you if you have a process that you think is truly novel, because as part of that bargain of getting the patent, you have to put all that information into the patent application. So after 18 months or whenever it publishes, that now is all available to the public. So if you have something that's really an advantage in terms of a more efficient, or for whatever reason, a better process, for instance, by making that available to the public, you've given away that advantage, unless you're able to take advantage of that right to exclude to keep everybody from doing it for that period of time. So in some instances, if you think you have something that would be hard to sort of police whether somebody's copying it, but is an advantage for you to be able to perform it, it might be better to keep that as a trade secret, and just not tell others about it. I mean, the differences between a patent and a trade secret kind of in terms of pros and cons have more than just that. So for instance, trade secrets can be protected for as long as they're kept a secret. So whereas a patent is, you have 20 years basically to take advantage of that. If you have something that could be useful technology or useful information for longer than 20 years, I mean, the sort of textbook example is like the Coca-Cola recipe, like something like that. I mean, generations and generations, if they're still using it, it's something that's going to continue to have value. Nobody will be able to make a generic version of it. So if it's something that has a really long kind of life of value and something that can't be just discovered. So with a patent, if you have protection, whether or not somebody ever saw your patent. So if you have something claimed, somebody came up with it, without ever having known of your patent, it doesn't matter. As long as you have a patent, you can stop them from doing it or sue them for infringing it. With a trade secret, it's a complete defense to misappropriation of trade secrets if you have independently come up with that information yourself. So the other sort of important thing is, with a patent, if you're first to file it and you're first to get that right, you can stop everybody else from doing it, even if maybe it was something that was fairly easy to come up with. As long as you were first, now you can be the only one to do it. With the trade secret, if it's something that can be fairly easy to come up with, there's not maybe a lot of value in keeping it as a trade secret because other people will just find a way to do the same thing, and then it will no longer be a trade secret.
Yeah. So what is misappropriation of a trade secret? Like how there is some legal protection for trade secrets. Where is that line? What is the actual protection?
Yeah. So the sort of requirements, I guess, for a trade secret is it's something that's by nature is secret, so it's something that other people don't know. It's something that has value because other people don't know it, and it's something that you keep reasonable efforts to maintain it as a secret, and that gives you the right now to keep other people from, if they've found out about it, from then going and taking that information and using it to their own advantage or to your disadvantage. So the misappropriation comes when somebody who learns of your information, if they're bound by like an NDA or another agreement that they can't take advantage of it, if they go and take advantage of it anyways. So if you, for instance, deciding whether or not you want to have a partnership with another business, and under NDA you show them some information about how your business runs, and then they go and copy the information for themselves and use it, like that would be a pretty clear case of misappropriation, because that information was only for for your value to for your use, and you didn't give them the rights to use it themselves.
Great. Well, I want to touch on a big change that was made to the patent process that I think is extremely influential on the patent landscape right now, and that's the change from first to invent to first to file. And what can you tell us about how patents previously were processed and protected versus how they are now that we have the first to file system?
Yeah, so previously, if there were two people at the patent office that both were trying to get an application on the same thing, the way this was resolved was there was something called an interference, where both parties had to introduce evidence to say who was the one that actually had the idea first, who conceived of this invention before the other one. So this was the old system, which was called first to invent. And what that meant oftentimes was you could sort of hold off on filing a patent as long as you maintained really good records of what it was you were doing. So if you kept lab notebooks and maybe you had somebody sign them at the end of every day, and you kept this all detailed and you had logs and everything, you could maybe wait 10 years or 20 years before filing a patent application, as long as you could go back and show you were the first person to invent it, even if somebody tried to file a patent application in the meantime. Now, and this was made to sort of harmonize the US with the rest of the world, which also followed this first to file system, you just have to win the race to the sort of patent office. So you have to be the first one to file your priority application, which generally in the US may be a provisional application, but it can be an application filed anywhere. So it's whoever is the first one to file a patent application anywhere in the world now has priority for everything in that application. Of course, you can imagine as a patent office, it's kind of removed a lot of the administrative burden, because you don't have to have these interference proceedings anymore, because it's very easy to see if somebody's filed a document first, that document stamps, or whatever the electronic equivalent is when it gets submitted to the patent office, instead of having basically like an administrative hearing where people introduce evidence to show that they were the first one to do something. But it was maintained in the U.S. for a long time, just for sort of political reasons, or kind of like international trade reasons, because it gave the U.S. an advantage over other countries. So you can imagine, somebody from a foreign country filing in the U.S. A copy of what a foreign application would have been. Oftentimes, they would try to do that very, very quickly, because they were doing it sort of in compliance with following their, the rules of their country. Whereas in the U.S., people sometimes could rely on older evidence, or wait longer, or do things that gave U.S. companies an advantage. So ultimately, as part of sort of international trade agreements, the U.S. Had to change their law to harmonize with the rest of the world. But it makes it much easier for patent lawyers too, I think. But it also kind of changed the landscape a little bit. And now, in that, like, people really should think about filing applications as quickly as they can. And oftentimes, it becomes really important, because in a fast-moving space, for instance, many companies may be trying to file on a similar thing all around the same time.
Well, there's sort of two forking paths I want to go down. I do want to talk about the sort of international patent landscape versus domestic. But first, can we talk about what prior art is? And, let's say that you're a processor, and for the past 10 years, you've been practicing a trade secret process that you've been, deriving a lot of value from. And then somebody goes and decides that rather than keeping it a trade secret, they want to patent it. They're going to get their filing in first. Does that mean at that point effectively that, you are liable after the date of filing for if you continue to use that process that you've been using for many years? Or, what is prior art, and where's the line for prior art versus what would be a patent violation?
Yeah, so that's a good question. And I guess in terms of prior art, the basic requirement is it has to be public. So something that somebody's doing as a trade secret is not going to be prior art to anything really. So to be prior art, it has to be something that's available somewhere to the public. But that universe of what is prior art is very broad. So as long as it's public, it doesn't have to be in a particular publication, or it doesn't have to even be in the US. It doesn't have to be in English. It can be anything that's filed anywhere. There's some examples I think people probably learn in law school, where it's like a foreign thesis on something that's like, maybe there's like one copy and it's printed in the library somewhere, but it's like shelved on the wrong shelf, and nobody could really find it. But as long as it's out there and it exists, it's prior art. It could prevent somebody from getting a patent application. Of course, that's only in theory, because what's prior art to a patent examiner is just going to be what the patent examiner looks at and what the patent examiner has in front of them. And so something that's I think resulted in a lot of very broad patents being granted in the cannabis space is because a lot of what's prior art in the cannabis space is not things that have been either in a prior patent application, which is really the first place a patent examiner looks. So patent examiners, they're best suited to see like what's in a prior application, how is this different from what's already in prior applications. So when cannabis patents first started being filed, which wasn't really until the end of the 90s and 2000s, there was really nothing that was sort of traditional prior art for a examiner to look at. So, because examiners have fairly limited time with each application, and maybe they don't know the field all that well, they may overlook things. But somebody may be able to, like a competitor that's worried about an application, can say monitor an ongoing prosecution and submit something that they know is prior art, maybe the examiner would miss. There's a little bit of a window after a patent grants that anybody can file like a post-grant sort of challenge of an application. Otherwise, you just have to wait potentially to see if there's a litigation, maybe something can come up. And of course, you can have a motivated adversary in litigation with maybe more at stake that can go and find that thesis that's been misshelved somewhere in a foreign language.
So speaking to the company that's been practicing a certain something, and say it was based on a thesis or a dissertation project that somebody has done, and then they've gone and made a company out of it, and somebody else but they haven't patented it for whatever reason. Although these days the academia is usually pretty aggressive at trying to pursue the patents of their researchers. But let's just say somebody goes and creates a private company. They haven't patented it, but they do have a publication about the process. And then someone goes and patents it. They don't catch it. They're not doing ongoing discovery, or for whatever reason they're not aware of the filing. And then that company that has gotten the patent issued comes and attempts to enforce the patent on them. Can they rely on that dissertation or that publication that they have as a defense in court, even after the patent is filed and granted? If they went to court, if they can provide prior art, it's very specifically dated, it's specifically public, that effectively is going to eliminate the protections of the patent that was granted. Is that true?
Yeah, I mean, I think if we make a few assumptions, that would be true in theory, at least, and then we can kind of break down how we would see this come out in kind of practice. I mean, one of the assumptions we would make is, like, is that really prior art that really does disclose exactly what it is that the claims disclose? So, we mentioned a little bit about the importance of the claims, but one of the first things that happens in any litigation is there's like a sort of initial stage called claim construction, where the judge decides what the words in the patent claim actually mean. So, for instance, the claim construction is going on right now in this Canopy GW case, and GW is arguing that the Canopy claim, which says subcritical temperature and pressure conditions, should mean subcritical temperature and subcritical pressure conditions. And Canopy is saying, well, wait a second, it doesn't have to be both subcritical temperature and pressure, because that actually eliminates quite a bit of the subcritical range as to be subcritical in general. So that's just kind of an example, but like there's always going to be a stage at the beginning of like a patent litigation where there's this early hearing where a judge decides what the words of the claim mean. And the patent owner, if they have knowledge that there's potentially this prior art that's out there, they may try to find a way to kind of narrow their claims to avoid it, or do something else to make it not as kind of as impactful during the litigation. But assuming it really does cover everything, the patent owner is not able to sort of change the way their claims are interpreted to sort of avoid it, then yes, I mean, if it's filed, or if it was published and available to the public before the patent was filed, before that earliest priority date, then in theory it should be enough to invalidate the application. But of course, that means typically convincing a jury that
Right.
It really covers the same thing. And in a technical subject matter, that can sometimes be more difficult than it seems to scientists or people that are really familiar with the technology.
Well, so that's what about forums, right? I mean, that's the big I think topic that comes to a lot of people's mind, especially in the cannabis space right now.
Mhm.
Is there's a lot of somewhat open process disclosure and development that goes on various forums, and has for many years. And then we also look at websites that are somewhat forum-like Skunk Farms, where they have sort of articles that are more publication sort of structured, but then there are also forums that engage with those publications and comments and things like that. Those are all publicly available. So in theory, so long as those are brought directly to the attention with publication dates that are typically listed on every forum, those do serve as prior art. Is that?
Yeah, I mean, I would underscore your in theory. I mean,
Yeah.
You kind of have to like just pause for a second and think of the patent examination process, and remember, these are government bureaucrats who are generally rewarded on just getting through applications. They, obviously have like a supervisor who's making sure they're, hopefully doing a good job, but they're just, kind of trying to do the best job they can with a sort of the things they have in front of them and the time they have to do it. So it really depends on the examiner. And some examiners may kind of be a little bit familiar with cannabis. Maybe they enjoy cannabis themselves. Maybe they're just curious people and they go and do Google searches to spend a little bit more time trying to track things down. Or maybe they've had applications involving cannabis extraction before, so they're kind of familiar with these forums. But on the other hand, maybe they're people that have worked for 30 years at the patent office and they're still using the kind of old systems and habits that they've had for a long time, just looking at like kind of specific scientific articles and things, and they're not the kind of person that's going to go and do any sort of additional work and just wants to get home early at the end of the night. And I mean, in the prosecutions I've had, I've been surprised with some examiners being very rote. And you can imagine too, this is, even though it's the patent office, they're relying on very old systems. I'm kind of imagining them at their desk with like a command line prompt pulling up like an old library terminal, like prior art. But I've had some examiners like actually cite like YouTube videos and things to me that I was pretty surprised, because it showed that they were really doing kind of like independent work. But so I guess that's not really like a very satisfying answer, maybe, knowing that. But because this is a problem, so there are examples of ways that people can take this information or kind of package it in a way, or just make examiners aware of it. And that's happened in a variety of different spaces. And there have been a number of projects, even going back decades, where different organizations have tried to make specific information that they feel is relevant to them available to an examiner. And so like in the psychedelic space right now, actually, because the psychedelic space I think has a lot of similarities with the cannabis space in terms of the amount of prior art that would be easily accessible to an examiner. There's a project right now called Porta Sophia, where it's a nonprofit and they're getting volunteers, and a law firm is helping them basically bring together all this information, like on forums, to have it in one place, and then actually reaching out to the patent office and trying to teach examiners, like, this is something that you can have access to. And so, that's something that can happen to try to avoid these problems of things kind of slipping through.
Right. But if you are intending on pursuing patent protection for your ideas, and you go on a forum and talk about those ideas to try and get input from experts in the field, you should be aware that whatever you publish on the forum effectively is prior art that could be used against you in litigation around that patent later on, if the other side does discovery and finds that publication, those posts on the forum. Is that?
Yeah, I mean, maybe, and I might not be understanding exactly who the people are here in your kind of hypothetical, but if it's the patent owner talking about their own invention, like before they filed it, there's kind of a grace period. So you can actually like publicly disclose your invention for up to a year before you file it. Not true in every other country. It is true in North America, and in a couple other countries. So like in other countries, and actually most of the world, but in Europe and the UK, if you tell anybody about something, like not under NDA, or if you publish anything, the next day you no longer can file a patent application on it. The US, you have a whole year of grace period. So, you can tell people things at a conference, you can sell products that you later want to patent, or sell, equipment. You can do anything that would be prior art, and you have a year now to file on it. Of course, during the year, somebody else could file on it before you, because now you've disclosed it. So that's a danger. But you're able to save those things. So if it's the inventor's own disclosures, for instance, on a forum, that wouldn't be prior art to them, unless it was a foreign application, or unless it was over a year before they're found.
Gotcha. So well, that brings up a whole other risk. You said if it's their own. If you publish something on a forum and then within a year somebody else sees it and they go and attempt to file a patent on it, is it treated any differently, or is it just any prior art that's published within a year of the filing date is disregarded?
No, it has to be your own, only your own disclosure. So the inventor themselves gets like a year grace period. But yeah, I mean, if it's somebody else's. So I guess when I mentioned that, it was just somebody else could sort of like incorporate information from the previous year, but they couldn't file on something that's identical.
Yeah, I see this question. What if you're on a call from the or Zoom from the US to UK?
This is somebody that knows how to ask a good question. That's a really good question. I mean, I think it really doesn't matter though. So if you're filing in the UK, well, I mean, if you're filing in the UK, if it's prior art, it's prior art regardless of where it is. I mean, so the call Zoom, I guess, if we're treating the call in the Zoom as prior art. So if it's like, I'm presuming for the purpose of the question, you mean the call or Zoom is somehow public or somehow is um, becomes available. But yeah, I mean, so if you want to file it in the if you want to file any application in the UK, any statement you've made that's public or anything that you've disclosed that could be prior art anywhere in the world will prevent you from being able to file on it. There's a couple very, very narrow exceptions. One of them is if the disclosure is for purposes of an international exposition. I think one of the world fairs, they had all the different countries change their laws to make sure that they would be able to freely disclose their inventions without worrying about not being able to patent them after. Or if it's done against your will. So if somebody like takes some information from your facility and publishes it against your will, then you can the next day you can go and patent it.
Yeah, so if you get hacked and
you get hacked. Yeah, there's like if you're on the dark web somewhere, then you can still go ahead and file.
So it is let's talk about international versus domestic patents. Then we've sort of skirted around it a lot. What I file a patent in the United States, I get a provisional, or even if I get it issued, at that point, it is going to become published in the United States at some point, right? What's to keep somebody in China or somebody in any other country internationally from reading that patent filing and then filing a patent with it at their patent office to protect the same idea in their country?
Well, it would be your patent. If they can read it, it's prior art, so they couldn't file another application covering the same thing. Right. So yeah, I mean that would be the reason. So I mean, I think every country has a similar rule to the U.S., which is if it's prior art anywhere in the world, it's prior art in that jurisdiction as well. So prior art is global. So as soon as something's published anywhere in the world, nobody else can, besides the inventor in the U.S., can file an application on it. Yeah, I mean, one thing we didn't talk about is just kind of like the flow, and I don't know if you're curious just about that in general around like filing applications, but I mean the general sort of procedure is somebody files one priority document somewhere in the world. Oftentimes it'll be a provisional in the US. And then you have 12 months to file your non-provisional. Oftentimes that non-provisional, the first one will be a patent cooperation treaty or called like a PCT application, which then gives the patent applicant another year and a half if they've just filed it from a provisional, or 30 months if that was the first document they filed, before they have to file in any of the other countries that the PCT allows them to file in, which is pretty much every country in the world with a couple exceptions. So in terms of just foreign filings, people can file one application, like a provisional, one PCT, and then basically have 30 months to decide whether they want to file in multiple countries.
Right, and then so you have that. It's essentially notification to the international patent agencies that there is a protection that's in the pipeline that could potentially then be protected in other countries. So it's basically disclosing that it is going to be who can then file the patent in the other countries, right? And then, but you still have to go individual country by country from that point and get the protection in each country that you want to enforce in. And correct? And is there a time limit that you have to fall within for those protections?
Yeah, so it's 30 months from that first document. So if it's like the provisional, if you have 12 months from the provisional to the PCT, it would be 18 months after the PCT, or it's just 30 months from that first document is when you basically have to file in any foreign country from a PCT. Some are 31 months, but it's basically 30 months. And you're right in the main that it's basically it's country by country. So there are a couple jurisdictions where you can get a European patent, which covers some of the countries in Europe. There's also an African kind of multi-country jurisdictional patent. But generally, you need to hire patent lawyers in every country you want protection, get your initial document translated into whatever language that patent office is in, and then pay for individual prosecutions in every country. So it can be, I mean, if we haven't really talked about cost yet, but it can be very costly to, to do that in more than a handful of countries, because, you're now hiring lawyers in maybe 10 different jurisdictions and paying all the filing fees and translation fees, and for all the negotiation with examiners, this can be a lot of lawyers' hours. But there's no like streamlined way to get, like, there's no international patent or like, way to get a single patent that really covers more than just a handful of countries.
Right. So we are coming up at the end of our presentation. If you have any additional questions, please do post them now. To round out our time here, basically, we haven't talked about it, so we probably need to touch on it at least a little bit. This idea of a patent troll, or a company that is not in the business of inventing products, but is in the business of either purchasing or otherwise acquiring patents and then pursuing litigation around those patents. Have we seen any action in that on that front? Any indication that that's happening? Should people be worried about it? And how do we, how do you, if you're forming a new business, you want to be innovative, you want to use innovative, processes. How do we protect ourselves against being, pursued by these companies that basically make all their money by litigation?
Yeah, I mean, I would be very rich if I could tell people how to protect themselves from trolls, because that's the question that everybody wants to know. Less so, I think, thankfully, so far in cannabis, but certainly in electronics and software, where trolls have been so successful in getting kind of shakedown settlements from just about everybody. And, to the point where there's been anti-troll litigation, anti-troll legislation, and some states have their own statewide anti-troll legislation. But so far in cannabis, at least, we haven't really seen anything. I mean, like I mentioned, there's only been 2 patent litigations filed so far, and both of them have been between competitors, and of course with Canopy and GW, between some of the biggest competitors. There have certainly been lots of concerns about it. So I think we probably know some concerns in the extraction space. I mean, one of the sort of most notorious patents from just a handful of years back was Biotech Institute's patent that covered a very broad, I think I even saw somebody say it was 50 to 70% of all plant strains. I don't know if anybody knows this 554 Biotech Institute patent. There's like a really great GQ article written about the kind of search for who the people behind it were. But, so while that's still a possibility, and, it's something that can potentially happen once there's, I think, more consolidation in the market, and there's, bigger sort of these, reasonable royalty basis to go after. We may see trolls. We certainly have seen them in pretty much every other industry, and with a number of what one would call low quality patents that could be invalidated if the right prior art was in front of them out there. There's unfortunately a pretty good chance that that'll happen. I mean, and there really aren't great solutions. There are some ways of using patents defensively. There's some companies that sell like patent risk, sort of patent infringement risk insurance. The EFF, if people want to read, I probably can't go through every way people can respond now, but because it's been such a big issue in the software space, like the Electronic Frontier Foundation has some really good publications on sort of how to deal with trolls. I mean, there's been a lot of it written elsewhere. Hopefully it'll be a few more years before we see that kind of activity in cannabis, and by that time people will have come up with better solutions, or there'll be legislation preventing it.
Right. Yeah, we have seen some companies building portfolios of IP. So it's not and that don't seem to be using all the IP that they're requiring. So there's certainly something to stay up on. To answer your question really quickly that we've seen here, so the specific GW or Canopy versus GW case that we've been referencing is actually specifically about a case where GW is using a technology outside of the country that Canopy claims is protected by their patent, and then importing that product from outside the country to the US, and they're seeking royalties for that product that has been sold within the US. So the answer to your question, Brennan, is yes, that is actually exactly what this case is about.
Yeah, and that's another really good question, Brendan. I feel like you either, well, for some reason you do tend to seem to know a lot about patent laws. You're asking good questions, but yeah, I mean, so generally a claim is only enforceable in the jurisdiction where that patent was granted. So a process claim, which covers the extraction of cannabinoids, for instance, that process would normally have to take place in whatever jurisdiction the patent was granted. So in the US, GW, of course, is performing their extraction process outside the US. But the US has a statute that covers infringement for the product of a patented process, even if that patented process is outside the US. So if GW performs the allegedly infringing process outside the US, but then imports the product of it into the US, then that gives the patent owner a basis to sue for infringement of that process, even though the process itself is not performed. And there's some kind of ways of getting around that. So if the product is materially changed before it's imported, or if it's only like a small kind of insignificant part of a much broader thing. So you can think of like a car, if somebody's, for instance, creating a new piece of electronics that goes in a car dashboard, and then somebody imports an entire car into the US, that might be a way of that not being a basis for a lawsuit in the US. But generally, for something like this, because they're directly importing that product or that process into the US, it gives them a basis to sue, even though they're suing on a US patent. I see you have one other question in here twice, so I guess I'll take a stab at answering it. And I guess I'll read it just so everybody can know what question I'm answering, since they don't have access to the Q&A in the YouTube video. So this question is on a general IP note. Does the lack of inventive step in Gilgamesh's recent application mean that a patent will be rejected, or do they get a chance to reformulate the claims? So I guess just to give the context for this, I think it may be, unless it's coincidental, because I tweeted about a Gilgamesh application that's a PCT application that had a written opinion that discussed the sort of validity or not of the claims that are presented in that PCT application. So I guess to take another step back and give a little bit more context to this. So we talked about the PCT application. The PCT itself is not really examined in the sense of it can't become a patent. You don't get a PCT patent. It just gives you the right to file these national patents. However, when the PCT is pending, you actually do get a written opinion and a search report from an examiner. You can choose which examiner you want from which jurisdiction, the US or Europe or Korea, or there's a few different jurisdictions to choose from. And then you get, actually before your PCT publishes, a written opinion that tells you if that examiner thinks the claims that you presented in the PCT are novel, if they're obvious, or and if they have utility. And so thinking about the sort of PCT process, that's a way that a lot of companies sort of get kind of a first crack at understanding whether that expense of filing in every country around the world is going to be worth it, because they get to see kind of what an examiner thinks of their claims, what the prior art maybe they missed, or how somebody's looking at it. But so for this particular one, it did get a written opinion, I think, that said that some claims weren't inventive, so they were obvious. But the PCT, those particular claims aren't the last ones to be able to be filed. Basically, the whole negotiation with the patent examiner, the back and forth is generally not just about trying to convince the examiner, but it's about taking the examiner's advice sometimes that like prior art is potentially standing in your way, and you can amend and narrow your claims to get around that prior art or change them a little bit. So yeah, so this written opinion that's at the PCT right now, it's referring to specific claims, but this particular patent applicant, when they enter national stage, or even they get a second chance in the PCT if they want to refile claims, they'll get a chance to take whatever kind of advice was given in that written opinion, and if they think it's valid and they think that prior art is in fact potentially in anticipating some of their claim scope, they can narrow their claims. And so I guess to answer your question in somewhat of a long way, yes, they will get a chance to reformulate those claims, both one more chance at the PCT stage if they want to, and then as soon as they enter a national examination, they can file a preliminary amendment and file new claims, and as many times as they want with a U.S. examiner, keep trying to get new claims approved. So yeah, that's
Great.
answer that one.
Well, Graham, thank you so much for coming on. This has been a great first delve into intellectual property. There's so much to go over on this subject that I think it's likely that we'll touch on it again in some time in the future. So thank you for joining us and for sharing your expertise. For those of you who are out there interested in following up, you can find Graham. Actually, why don't you tell them the best way to get in touch with you?
Well, the best way to get in touch with me, my firm name is Calyx Law. So you can find Calyx Law on just the internet. I do spend a lot of time, probably more time than I should, on Twitter. But so I'm often in conversation there, or try to be around cannabis patents and psychedelics patents. So you can find me at Calyx Law. And yeah, please do reach out.